calling the joint hearing on human services and health, 305 calendar at room 225. This meeting, including the audio and video of remote participants, is being streamed live on YouTube. You will find links to viewing options for all Senate meetings on the live and on-demand video page of the legislature website. The Zoom meeting and YouTube live stream event will include the following agenda, which is a 3:05 p.m. HMS-HTH agenda and the 3:15 HTH-HMS agenda. In the unlikely event that we have to abruptly end this hearing due to major technical difficulties, the committee will reconvene to discuss any outstanding business at 3 p.m. Tuesday, March 23rd, room 225, and a public notice will be posted on the legislator's website. For the people participating remotely, all testifier audio will be muted and video disabled until shortly before it is your turn to testify. There will be a 2-minute time limit per testifying, and I will be reading a list of people who submitted written testimony for each measure, and we apologize if the closed captioning doesn't accurately transcribe the names. If you're interested in reviewing the written testimony, please go to the legislator's website. You will find the linking on the status page for the measure. So here for Human Services is Chair present, as well as remotely Senator Ocasio and Senator Favela. Chair Kehokalole, the presence of your members.
Thank you. I'm joined here by our Vice Chair, Senator Baker, and members Senator Stan Buenaventura and Senator Favela. We also, on the committee is also Senator Sharon Moriwaki. Thank you.
Okay, thank you very much. Okay, first up, HB 311, relating to Nursing Facility Sustainability Program, extends the Nursing Facility Sustainability Program to 2024, allows us the Nursing Facility Sustainability Fee to be used to enhance capitated rates for the purpose of paying quality incentives, allows nursing facilities 60 days to pay the Nursing Facility Sustainability Fee, specifies nursing facility sustainability fee limit is 5.5% of overall net patient service revenue, removes the per resident daily maximum fee of $20 for each facility, specifies facilities that meet certain exceptions shall pay a reduced daily fee in comparison to other participating facilities, and appropriates funds. Okay, first up for HB 311 is Department of Human Services, MedQuest. I see Judy Moore-Peterson.
Good afternoon, chairs, members of the committees. My name is Judy Moore-Peterson. I'm the MedQuest administrator, and we stand on our written testimony and strong support. Thank you. Available for any questions.
Okay, thank you very much. Next up, we have Colette Masunaga testifying for Queens Health Systems in support. Is Colette?
Madam Chair and members of the committee, J.C. Mike-Kilanick on behalf of Queens Health Systems, standing in on our written testimony and strong support. Thanks very much.
Okay, thank you very much. Next up, I see Hilton Rathel for Healthcare Association of Hawai'i in support.
Thank you, chairs, members of the committee. I'm Hilton Rathel, President of the Healthcare Association of Hawaii. The Healthcare Association of Hawaii stands in strong support of HB 311, HB 1. We stand on our written testimony. Thank you.
Okay, thank you very much. Okay, nobody else having registered to testify. Those who have provided written testimony are Eric Abe for Hawaii Primary Care Association, Amy Lee for Aloha Nursing and Rehab Center. Anybody else wishing to testify on HB 311? Seeing none. Members, any questions? Okay, seeing none. Shall we move on? Chair Kehokalole? Okay, I see him nodding his head, so we're moving on. HB 1283, dementia training, Alzheimer's disease, requires the employers of first responders to develop and provide dementia training to first responders, permits the Executive Office on Aging to set standards, frequency, and coordination of Dementia training. First up is Department of Health and support.
Good afternoon, chairs, San Buenaventura, Tokolole. This is Lauren Kim on behalf of the Director of Health. The department has submitted comments. We support the intent of the measure, certainly. However, we have an issue. We have concerns with amending 321 Part 18, which is related to emergency medical services. EMS technicians are one of many groups of first responders. We think that placing it in 321 Part 18 really doesn't do this measure justice. We have no leverage over county police, county fire, and all the other first responders as defined in this measure. There would be no enforcement provisions. It would just sit there as an orphan section, so to speak. We do recommend that it either be amended to 349, which is the area of statute that specifically deals with Alzheimer's and dementia-related disease, or Chapter 46, which is related to counties, or another possibility is concession law. Again, we support the intent of this, but nothing is really gained by putting this in 321 Part 18. Thank you for the opportunity to testify.
Okay, thank you very much. Okay, next up, Department of Health Executive Office on Aging and Support.
Good afternoon, Chair. This is Aaron Arakaki from the Executive Office on Aging. We submitted testimony with comments, and we'll stand on that and available for any questions.
Okay, thank you. Next up, Department of Health Executive Office on Aging, Carolyn Kadira with comments. Next up, Executive Office on Aging, Debbie Shimizu with comments. Okay, I'm assuming the last speaker is speaking for all three. Next up, I see Mike Lambert, Officer Lambert or Captain Lambert, Honolulu Police Department in opposition. Please proceed.
Good afternoon, Chair, Vice Chair, Committee. We just want to clarify that we like the intent. We're not against training at all. It's just the oversight being given to a different agency could be problematic for us. So if it would just be changed to set recommendations, which was suggested by the Alzheimer's Association, which would just provide guidance to the first responders, and we would be willing to support in that. As written, we have to approve. Thank you.
Okay, thank you very much. Okay, next up, I see Ian Ross for Alzheimer's Association in support.
Thank you very much, Chair, and also Chair Kolola as well. The Alzheimer's Association is in strong support of this legislation. Right now, 29,000 individuals have Alzheimer's who are over 65, and that's expected to grow to 35,000 by 2025. There's 25,000 caregivers who provide 20% more care than 10 years ago. And I say this all to indicate that more and more individuals are likely to fall between the cracks, meaning that first responders might be the first to approach individuals in distress who have dementia across our islands. So with that in mind, we believe this training is very necessary. 10 other states have some type of training for first responders in place. And as the Major said, we have submitted some recommendations that we think can begin to make sure that all parties involved feel that the language will be appropriate, understanding that first responder employers might be able to best select the type of training available, just mandating that training and letting the Executive Office on Aging provide recommendations, I think is very good. And one last comment, Lauren Kim from the Department of Health pointed out a few other places where the statute could go. We have no complaints there. We definitely would follow the lead of the chairs in the discretion of this. Thank you very much for your time, and I'll be available for any questions.
Okay, thank you very much. Next up, I see Calvin Hara in support. Mr. Hara, are you present?
Yes, thank you, Chair and members of the committee. My name is Calvin Hara. I've been working in long-term care for 30 plus years. Presently also a volunteer for the Alzheimer's Association. I'm in support of this bill. In addition to my written testimony, 13 days ago, in helping a relative, did a 911 call, firsthand, fresh knowledge about our wonderful response from our Honolulu Fire Department and from EMS. The additional support that we can give our first responders on dementia and Alzheimer's would definitely help our citizens. As you know, dementia can affect people in many different ways. I also am in agreement with any recommendations to the bill as mentioned by Major Langford and the department and Ian Ross with the Alzheimer's Association. Thank you. I'm open for any questions.
Okay, thank you very much. Next up, I see Dr. Poki Balaz in support.
Hi, fellow chairs and committee members. Thank you for giving me this opportunity. So I stand in support of the bill, not just as someone who, like Calvin, is in long-term care services right now, but also as a clinician who sees caregivers and patients in memory care, but most importantly as a caregiver. And as a caregiver, I have made the call for my father directly to EMS, which is a wonderful service and everyone is great there, but unfortunately my father does have Alzheimer's, and due to the fact that he has Alzheimer's, as this was unfolding, the ones who responded did not have or did not understand what that meant and how to change to the situation to be appropriate to my father's disease and what was happening. So needless to say, the experience at that time was not the best. I don't think that was the intention, but so I'm very much in support of this bill to help all of us in the medical community to gain the knowledge and experience we have so that we can attend to those under our care and support the families as well. So I'll be available for any questions. Thank you.
Okay, thank you very much. Okay, nobody else having registered to testify, written comments, written testimony has been provided by AARP, Audrey Suga Nakagawa in support, Lawrence Enomoto for Aloha Chapter Alzheimer's Association in support, Melissa Borjaguez, CareOps Consulting LLC in support, and about 22 other individuals in support. Anybody else wishing to testify on HB 1283 HD1? Seeing none. Members, any questions? Okay, seeing none. Ready to recess for decision making? Okay, we're going to recess for decision making. Recalling the 305 calendar for Human Services and Health for decision making, Chair's recommendation for HB 311 is to pass with amendments. Chair votes aye. Senator Ihara.
Aye.
Senator Ocasio.
Aye.
Senator Misalucha.
Aye.
Senator Favela.
Aye.
Thank you very much. Chair Kehokalole.
Health Committee, same recommendation. Chair goes aye.
Vice Chair goes aye. Senator Moriwaki? Senator Moriwaki?
It's on the other hearing.
Senator Buenaventura?
Aye.
Senator Favela?
Aye.
Chair, your recommendation has been adopted.
Okay, thank you.
Very much.
Okay, so for HB 1283 HD1, Chair's recommendation is to pass unamended with all members being present. Any reservations? Seeing none, any no's? Seeing none, recommendation is adopted.
For the Health Committee, same recommendation. Chair votes aye.
This is to pass unamended?
Yes.
Okay, thank you. Chair votes aye. Vice Chair votes aye. Senator Moriwaki is excused. Senator San Buenaventura.
Aye.
Senator Favela.
Aye.
Chair, your recommendation's been adopted.
The 30 Thank you. So the 3:05 calendar is adjourned.
Okay, we're going to convene the 3:15 agenda on Thursday, March 18th. A joint hearing between the Health Committee and the Human Services Committee to consider House Bill 310 HD2 relating to health. This amends the definition of imminently dangerous to self or others. It authorizes the involuntary treatment of up to 30 days of patients who are subject to emergency hospitalization, diagnosed with a serious mental illness, or severe substance use disorder, and found to be lacking decisional capacity. It also requires assessment of patients who are subject to emergency hospitalization, diagnosed with a serious mental illness or severe substance use disorder, and found to be lacking decisional capacity to determine if a surrogate or guardian needs to be appointed to make appropriate healthcare decisions for the patient. First, we have the Attorney General's office offering comments. Do we have Deputy Suda on the conference?
I'm showing him to be available, Chair.
Oh, there we are.
Sorry about that. Thank you. Good afternoon, chairs and committee members. My name is Ian Suda with the Department of the Attorney General, providing comments on this bill. These comments are reflected in our written testimony, and we just wanted to emphasize one concern regarding the provision allowing for the involuntary treatment of patients due to a lack of decisional capacity. Hawaii statutes currently permit involuntary treatment of patients in facilities in situations that are emergencies or pursuant to valid court orders. These statutes are consistent with the leading Supreme Court decisions from our state, which require findings of danger or medical necessity after lesser alternatives have been exhausted. So the provision in question, as written, permitting involuntary treatment for lack of decisional capacity would run afoul of these laws and precedent. So we respectfully request that this provision be removed from this bill, and I thank you for your time, and will be available for questions.
Thank you very much. Next, we have Department of Prosecuting Attorney, Sitting County of Honolulu, offering comments.
Good afternoon, Chair, Vice Chair, both chairs, and Vice Chairs, members of both committees. Deputy Prosecutor Tricia Nakamatsu on behalf of Honolulu Prosecuting Attorney's Department. Our comments are basically limited to the word may on page 2, top of page 2. We would ask that you revert that, change that back to shall, as if somebody meets all of those criteria for emergency hospitalization, we feel that they in fact should be hospitalized according to the requirements of the statute. If someone's imminently danger to self or others, we feel that that really needs to be taken care of. It shouldn't necessarily be discretionary. And we defer to the Department of the Attorney General's with regards to constitutionality on that other section that they focus on page 2.
Thank you very much. Next, we have the Office of the Public Defender, Mr. Tabe, in opposition.
Thank you, Chair, Vice Chairs, and committee members. I am James Tabe with the Public Defender's Office, and we are in opposition. I just want to highlight and I guess re-emphasize Mr. Tsuda's arguments. This measure basically allows a doctor or the APRN to bypass court approval. I think Mr. Tsuda indicated that it violates not just, it says violates laws, it actually violates the Constitution, because the U.S. Supreme Court and the Hawaii Supreme Court has already requires that a trial court make specific findings, and it's listed in my, and I believe it's probably in other testimonies, that we need to make these findings before voluntary treatment can be provided. I mean, our patients, the voluntary committed patients at either Queens or at the Hawaii State Hospital, when they want to involuntarily treat somebody, especially on a non-emergency basis, they even seek a separate court order of court approval, and they go through that process. You have the assisted community treatment. That program also seeks before we could treat someone in that program, you need to have a court order. And this is so inconsistent with the other program, and it is, in my opinion, my own opinion, a violation of the Constitution, not just Hawaii, but as well as the federal Constitution. So I know best intentions are here, but I just think it's illegal at this time. And I am available for questions later on if necessary. Thank you.
Thank you, Mr. Tabe. Next for the Hawaii Disability Rights Center, Mr. Uschek.
Hi, good afternoon. Thank you. Thank you, chairs, members. Our testimony speaks for itself, so I'm going to be very brief. On the issue of 45 days to 90 days, we're not sure that it would make a difference in terms of getting a better perspective on people, but if the legislature thinks it would, that's a policy call, and we're not necessarily opposed to that. We're sympathetic to the idea of trying to get people treated with the longer-lasting injectables. I mean, I think the goal of the bill is really worthwhile, but as a lawyer, I mean, I do share the concerns of the Attorney General and others that provision is not really, the way it's drafted, I think, without judicial review, it's so open-ended for 30 days. I have a lot of concerns about whether it's going to hold up legally, and so I think if the idea is to try to use the long-lasting injectables, maybe there's a way we can get to that point without all those legal problems that the bill has. So that's what I would say about that. On the issue of the surrogate guardian, we're not necessarily opposed to that either, but I don't know if it's really been used in this area. I thought that's more like if you're in a coma or something and nobody knows what your wishes are, they try to get the family together and have somebody become a decision maker. Here you've got somebody who presumably after 48 get out of the hospital, and so I'm just not sure, maybe somebody that knows the reality of how that operates better than I do can enlighten you, but it seems to me that process of getting a surrogate probably takes a while, and so I just don't know whether it's going to work here, but if it will, I mean, we're open. We want to be part of the solution, so we're open to try to working on this. Okay, thank you.
Thank you very much. Next we have Institute for Human Services in support.
Executive Director. Oh, sorry.
You're good now. Thank you.
Okay, thank you. I'm Connie Mitchell, Executive Director for IHS Institute for Human Services, and we stand in strong support of HB 310. I think I am definitely not an attorney, and I understand the legal aspects that have been presented, but I also want to present the fact that there are so many people that are severely mentally ill that go untreated, for many times, and often in the emergency room we'll get a brief treatment. Then when they're released, it really doesn't do any good because they're back right where they are, just shortly after. I have submitted testimony, and I wanted to just reiterate one section of it. Like I said, I do acknowledge that some legal perspectives may find the short-term emergency treatment of persons without consent to treat unconstitutional without further judicial review. But instead, I would also like to alternatively ask that you could see it as an accommodation to a patient impaired by his or her mental illness for the right to treatment. Such an accommodation is in accord with the American Disabilities Act, which actually states that state and local governments give people with disabilities an equal opportunity to benefit from all their programs, including health care and social services. It also goes on to indicate that governments are required to make a reasonable accommodation for people who have, mental illness or disabilities, to policies, practices, and procedures where necessary to avoid discrimination. Right now, I really do believe that homeless people with severe mental illness are being discriminated in terms of their access to treatment. So I really, want whatever way, we can figure out, it doesn't have to be this way if that stated specifically in the bill, but I do think that people need treatment. I also wanted to say that we are open to the fact that, we have actually recommended that no edit be made to the definition for imminent danger, so that it revert back to the 45 days that's in statute right now. So, we're okay with it, but we just really need to have a way to help
Okay,
them.
thank you. Thank you very much. Next we have the Hawaii Psychological Association, Alex Lipton, in support.
Good afternoon. We support the bill. I'll try to be brief. Just two things. First, we're proposing an amendment so that psychologists would also be included, along with psychiatrists and APRNs with prescriptive authority, in determining whether or not somebody is competent to refuse psychiatric treatment. I don't know why anybody would be opposed to psychologists doing these competency determinations. I can tell you as a forensic psychologist, I've done over 1,000 competency evals for fitness to proceed in my career, and that's a lot more complicated than competency to refuse psychiatric treatment. Also, you don't need to be able to prescribe medication in order to determine if somebody is in need of treatment. When I worked at a community mental health center at the beginning of my career, decades ago, it was actually the psychologist that made the decision whether or not somebody would be referred to a psychiatrist for treatment. Now, maybe psychologists were left out because we don't typically work in emergency rooms where these evaluations might be done. But, you know, suppose a psychologist happened to be in an emergency room. I don't see any harm in adding us. And also, there's a danger this could be generalized to other situations. I'm not a lawyer. I can't comment on constitutionality. I agree with Connie Mitchell. This would increase access to services. And extending the 90 days from 45 days, I do think this is realistic based on my experience of evaluating dangerousness. Typically, it can take up to 3 months for somebody's medication to leave their system. Doesn't mean they're going to become violent right away, but it does take time before command auditory hallucinations or delusions would develop, which could lead to violence, and then it takes more time.
Thank you very much.
Situational factors to kick in. Thank you.
Thank you very much. Next for Queens Health Systems, Colette Masunaga offering comments.
Aloha chairs, Colette Masunaga for Queens. We do have comments and concerns, and we wanted to note that the request to the committee preserve the definition of imminently dangerous to self or others at 45 days. It's, I would say, virtually impossible to predict that if it was extended out to 90. And we did want to just note kind of the logistical concerns with regards to the changes to the MH4 statute, the emergency hospitalization, which right now is 48 hours, whereas the bill would allow for the additional 30 days for potential involuntary treatment. We do have concerns about logistically how this would actually programmatically impact the hospital, and we do have concerns about safeguards for patients.
Thank you very much. Next we have Keith Amemiya in support.
Sorry about that. Thank you, chairs, vice chairs, and other members of the Health and Human Services Committees. My name is Keith Amemiya, and I'm testifying in my individual capacity in strong support of House Bill 310 HD2. Like many families across the state, I have a loved one who's suffering from mental illness, and I strongly believe that this bill, if passed, will help many people who need help that aren't getting the help that they need. I am a lawyer, and so I'm confident that my fellow lawyers who have a stake in this bill will be able to work out the language to everyone's satisfaction so that the most vulnerable members of our community who aren't getting the help they need will get the help that they so sorely need. Thank you for the opportunity to testify.
Thank you very much. That's all the testimony we've received from individuals who indicated they would be present. Is there anyone else on the conference who would like to testify on this measure? Okay, seeing none, I'd like to note for the record, please proceed.
Thank you. Good afternoon, chairs, vice chairs, committee members. Apologies, I thought that we had indicated that we would testify. So the nice thing about having the privilege of going last is I can say kind of ditto to pretty much everybody's testimony. I think I would say that, you know, you have our testimony, we have concerns, we do believe that there is some path to working this out, but I would say that the disparate testimonies across the board indicate that there are still a lot of work on this bill that needs to happen. No, I don't know that there's many people that stand at the top of the line besides myself that has investment in seeing us do really, really well at taking care of those folks that are super vulnerable out there, like Connie is saying, that are dying on the streets. We've done a lot of work this year, over the last 2 years actually, to try to get the services and the systems out there to support the current statute and the current processes to get people treatment for their severe mental illness. So I would just ask that we maybe take a look at reorganizing the perspectives of this bill and maybe rewording it so that it's a little bit less running afoul of constitutional rights. Thank you, Chair.
Thank you very much. Is there anyone else who would like to testify on this measure? Okay, so I'd like to note the written submitted testimony of the Hawaii Substance Abuse Coalition in support, Thaddeus Pham in opposition, and the following individual members of the public in support: Jennifer Azuma Trupelik, Lemo Mikan, Ellen Carson, Stuart Silva, Lynn Unemori, and Maria Graham. Members, are there any questions? Okay, seeing none, I have a question for the Department of Health. Eddie, are you still there?
Yes, Chair.
Okay, and thank you for being present. The Attorney General's office in their testimony alluded to, well, they commented that the ability to require medication to be administered to individuals who've been involuntarily committed exists in the statute. But in your testimony, you explained that your feeling is that the issue here is that the mechanisms allowing for appropriate disposition and treatment are after the person is committed and assessed are a part of the problem. So it seems like we have a disconnect here that I'm hoping you could help explain.
Yeah, sure, Charlie. Let me clear that up. So when I talk about the after the disposition, what Queens testified is more than around 50% of the folks that are transported to the hospital under an MH1 order to transport for emergency examination. And after those emergency examinations, around 50% of those folks are identified to not be in need of hospitalization because of imminent dangerousness to themselves or others or other issues. And then upon that determination, there are many folks that still, and we've had these discussions regarding, you know, that kind of gap place of subacute stabilization or subacute admission, where they there's no ability for the EDs to retain the person against their will, and so they have to discharge if the person is not willing to stay, unless they pursue the other avenues such as MH4, etc. So that's where I'm talking about, where we really need to continue to focus on what happens after that involuntary assessment is done and they're identified as not being at the level for involuntary commitment or involuntary hospitalization at that point, and would be discharged, but they're still too ill for them to be successful either in a community-based setting or any of that kind of stuff. And that's where we've had discussions about maybe expanding, for example, administrative orders to treat, or having this idea that we could have a crisis drop-off center that would have the ability to, number one, do those assessments as well, Number two, maybe pursue the MH4 or even an MH6 from that point on, and then go through those regular due process avenues that we have available to us, which would eliminate the burden for the EDs, which would create a more comprehensive continuum of care for severe mental health crisis.
Thank you. Members, any follow-up questions? Okay,
Yeah.
seeing none.
I'm sorry, Chair. So I see Eddie Mercero here, and we don't have the Deputy Attorney General who provided the opinion. So I have a question.
Mr.
Ed,
Suda is on. Mr. Suda, are you still available?
Yes, I'm still here.
Okay, thank you. So you heard Chair Kehokalola's question to Eddie Mercero. When you say that we have the ability now, or upon to I guess for lack of a better term, I mean, provide the medication even though without consent to somebody who is considered MH1. Was that your opinion, that we can do that now? Or don't we need a guardian ad litem appointed? That's my understanding.
Well, if a patient doesn't have a guardian or somebody to make those healthcare decisions for them, the avenue still exists for medical professionals if they determine that treatment is necessary in an emergency situation to render that emergency treatment. And what qualifies as an emergency is ultimately left to the determination and discretion of the medical professionals who are assessing and examining that patient. So there is an avenue, albeit likely a smaller avenue than what this bill is currently suggesting. So when the first draft of this bill came out and it was identified that a lack of decisional capacity was something that the legislature was looking at, we provided, and we're very happy that the legislature accepted our recommendations that you include in this section that if that was the case, if a lack of decisional capacity is assessed during this emergency phase, that triggers an automatic requirement for the patient to be assessed to determine whether or not they do require a guardian, so that a guardian could be appointed and on a permanent basis to be able to make those medical decisions for them.
Okay, so that wasn't really my question. It's not whether or not a guardian needed to be, I mean, a guardian should be appointed. The question is, because I think a lot of interest is, can we get these people who are unwilling to consent to medication because they lack decisional capacity, they lack the mental capacity to understand their situation. Can we give them immediate treatment? I mean, what is considered an emergency? Is it the fact that they are on MH1 immediately, that we put them into the emergency room? Can we at that time, without providing civil and criminal liability to the medical professional, can that medical professional treat immediately?
Well, these amendments are all done within the context of admission to a psychiatric facility, which is based upon findings that the person is eminently dangerous to himself or others as the primary reason for going through this avenue. So, there is an opportunity to treat that individual, but it's not for the reasons just because they lack decisional capacity. It's because there's an emergency, and these statutes suggest that one could view an emergency as a situation where there is an imminent danger to the individual, or that person poses an imminent danger to other people. But the definition of what constitutes an emergency is something that's not clearly defined, and something that the medical professionals who are in that situation have to determine, and also determine what medication or what treatment to rectify the emergency situation is appropriate.
I'm sorry, Chair, if you could give me a couple of more leeway, and I see Eddie Mercer chomping at the bit, but let me keep talking to the lawyer, okay? From one lawyer to another, and that is, the problem arises in this bill intends to lower the bar of imminently dangerous so that the emergency situation allows for the medical professional to treat without incurring civil or criminal liability, okay? Because then the emergency, quote unquote, has been loosened because the imminently dangerous comes from 45 to 90 days. That's my understanding. And my concern, and I think the constitutional concern, is by loosening that bar, is it constitutional? And you're saying it is. If it is, then we can pass this?
No, I mean, we're recommending that this provision be removed from the bill because we
Okay.
don't believe that it satisfies the State v. Codis case, which is the leading Hawaii Supreme Court case, which is also based off federal cases that deal with involuntary treatment.
That's okay. One last question. Would we be able to get around that constitutional issue if we just get a guardian ad litem appointed so that the guardian then can consent to treatment?
I mean, I guess generally, yes, it wouldn't be a guardian ad litem. It would be, a guardian of an incapacitated person. A GAL has a slightly different function in that regard. But guardians can consent to medical treatment.
Okay, thank you.
Thank you.
And Chair, I think Eddie Mercer wants to chime in.
Are there any follow-up questions of the members? Okay, I have a follow-up for Mr. Suda. In reference to the prior question, I didn't see a reference in the testimony to just codifying that constitutional standard. Would that rectify the issues with that section that you're referring to?
If you were to codify the standard that was promulgated in State v. Codis, I mean, it would be a different standard than the one that provision proposes, because you would be adding in on top of a lack of decisional capacity, you'd be adding on the imminent danger, the lack of lesser restrictive alternatives, which existing provisions are already available for people to utilize to get treatment when an individual refuses to consent to that. So I don't know that adding that to this section will help that purpose, or add something different.
So this subacute framework that the Department of Health has put together, in your mind, those would constitute less intrusive alternatives?
I'm not as regrettably, I'm not as familiar with those avenues as Mr. Mercer has indicated. So unfortunately, I don't think I can comment on that.
Okay. All right. Yeah. Thank you. Those are all my questions. Members, any further? No. Okay. Well, then I'm going to recommend we recess for decision making. Recess. Okay, we're going to reconvene for decision making on HB 310. Thank you all for being with us. So I'm going to recommend that we move this measure out with the following amendments. We are going to change all references in the bill from serious mental illness to just say mental illness, so that it's consistent with the statute. We are going to accept the the Honolulu Prosecutor's Office suggested amendment, changing the page 3, line 1 back to shall from may. we are going to change the definition, the imminently dangerous definition, back to 45 days. And accept the Attorney General's Office amendments to remove page 3, to remove the language in page 3, line 17 through page 4, line 11, because of the constitutionality concerns. I do think this is a really noteworthy issue. I think everybody agrees on that. We got to figure out a way to do better. But I don't think this decisional capacity discussion is quite ready yet. And I would like to note that we're going to keep the second section relating to the assessments to determine whether a surrogate or guardian should be assigned. And then for consistency, repeal the deletion in section 4 of the bill. We also have some technical non-substantive amendments. So we'll be passing this with amendments. Members, any discussion? Okay, seeing none. Vice Chair, SD1, Chair votes aye.
Chair votes aye, Vice Chair votes aye. Senator Moriwaki, still excused. Senator San Buenaventura.
Aye.
Senator Favela.
Reservations.
I'm sorry, reservations?
Yes.
Okay, and reservations for Senator Favela. Chair, your recommendation's been adopted.
Thank you very much.
Okay,
Chair.
for Committee on Human Services, same recommendation. Chair votes aye. Senator Ihara.
Aye.
Senator Ocasio.
Reservations.
Senator Misalucha.
Aye.
Senator Favela.
Reservations.
Chair, well, my recommendation has been adopted.
Thank you very much. We are adjourned.
Calling the Committee on Human Services 320 calendar, same comments as I had made at the 305 calendar still applies. And basically, first up, SCR 41, urging the Department of Human Services to study the feasibility of increasing payment to decision-making on SCR 41, urging the Department of Human Services to study the feasibility of increasing payment to Hawaii's community care foster family homes and expanded adult residential care homes for Medicaid recipients. Chair's recommendation on this is to pass it with amendments. Basically, we are creating a working group on SCR 41. Any comments, questions? We had heard this in the prior hearing. Okay, voting on SCR 41 with amendments. Chair votes aye. Senator Ihara.
Aye.
Senator Ocasio.
Aye.
Senator Misalucha.
Aye.
Senator Favela.
Aye.
Chair, well, thank you very much. My recommendation has been adopted. For SCR 70, well, this is exactly the, okay, SCR 70. We are requesting Department of Human Services to convene a task force to plan the certification and training process for community health workers to help address the social determinants of poor health that disproportionately affect low-income people. My recommendation on this, as I stated earlier, excuse me, was to create a, was to require the auditor, conduct a sunrise analysis on licensing and or certification of community health workers and change the title appropriately. Any questions, comments? Okay, seeing none. So chair's recommendation is to pass with amendments. Seeing all of the, and this is for SCR 70 and SR 52, which is the companion resolution. Okay, seeing all members in the committee being present. Any reservations? Seeing none. Any no's? Seeing none. Thank you for adopting my amendments, and we are adjourned.